last round table of the day.
Stéphanie, on y va. Alors là, avant d'avoir le keynote de clôture, nous allons parler de la rupture du contrat.
Okay, termination of the labor agreement is of course one of the key items in the reform tables to give better visibility of who will be. Of course, it's a big plus for the employer. But if you take a close look at what's provided for, you see that there are a few items which are very beneficial to the employees too, not just employers. So let's start with the employers' point of view. What are the items that might make the employee's life easier? Well, it remains to be demonstrated. The draft decree refers to the model based on the model or standard type letters, dismissal rights. You'll be able to fill in a SERFA, the standard form forms that will replace the standard dismissal form that you're supposed to send to your employees if you are the employer. Now, there have been a few typos or misprints or even errors in the text. Inability, incapacity, and 3 cases of redundancy or economic dismissal, individuals 1 to 10 and over 10. So I'll say the details, which remains are not finished off yet. It's more of a checklist than a genuine dismissal letter that could be used as such and sent out to employees, because naturally they're supposed to state the actual reasons for the dismissal, personal reasons. The CGT, among others, has already refused this. They're extremely unhappy with the ease of the offered to the employers. It may not be the case, as we'll see by next summer. There are limits to the reasons that can be used. So hopefully, and this is a good thing, the SERFA standard form is not going to replace the lawyer's role. Okay, it gets rid of a part of the formalistic bias. Yes, indeed. It gives the employer all the full checklists of the items. He has to tick all the boxes before he can actually draft his letter. So our role, as the lawyer's role, will still be useful. But if some managers want to do it alone, okay, at least they know what to go by in terms of criteria. It can be useful too for employees because he'll will have the opportunity to know what his rights are. I'll be coming to the specificities of the reasons, and the employee won't have to consult the labor code or hire a lawyer. That's his problem, whether he does this or that. But all the information will be there, easy to find and available. So these standards, these models, can be used both by the employer and will make their task easier. But in fact, all of them have already the standard forms, letters, and for employees, even though CGT doesn't agree with me, it's not an open door to excesses or abuses. You don't have to fill in the name of employee, and you're sure that the dismissal will be granted. The reason for dismissal will have to be scrutinized. So it's easier. It gives you some guidance as to the form of the letter, as to the substance or the merits. It's not going to change much. Now, the reasons. What are the novel features? Well, the possibility for the employer to specify the reason post hoc, either on the employee's request in other words, you are free not to fill in anything. Yes, you can just state a reason, and then the employee may ask the employee within 2 weeks of the first submission of the letter, may request further clarification as to the reason, or the employer may unilaterally decide to fill in or to complete the reasons stated in the letter. Now, the draft order provided for the possibility to supplement or to add another reason than the one initially stated. That was a bit too much, and the final order does only provides for the possibility of specifying, further clarifying or explaining the reason. Yes, because in the prior interview, you're supposed to discuss all the issues, all the reasons for the possible dismissal. You're not supposed to add any new reasons in your letter. So it's just to make it very clear what the reasons for dismissal would be. In my practice, in redundancies, I see that my colleagues state that the impact of the reorganization was not really envisaged. Nothing was done to modify, to alter the contract of the employee. Of course, in the standard, in the model, it does specifically say so. It shouldn't happen, especially if you has to be assisted by a lawyer, so it should be included in the letter, but it's not the case. You can clarify it even further, make it very clear within the 2 weeks after notification of dismissal letter. So much, that's the first plus, to make the not too much formalistic. Now, coming to the core point, a greater foreseeability or previsibility of the effect of dismissal. I'd like to show you the slide. So this is the table. Cap and floor based on the seniority of the employee, divided up into according to the size of the company. Now, this has been validated by the Conseil constitutionnel. So you see the numbers of employees. Of course, some companies that are within that second bracket have different floor. Could it be invalidated by the Constitutional Council yet another time? Well, the initial table, the current table, the one that is currently applicable, takes into account the Constitutional Council's rulings. Indeed, this employee seniority must be taken into account, and this is what you see here in this table. So apart for people who have been with the company for 1 year or 2 years at most, the minimum has been divided by 2. It was a 6-month salary so far. Now we're down to 3 months, a minimum of 3 months wage for companies in that headcount bracket. So divided by 2, same thing for the time given to challenge the decision. 2 years down to 1 year to challenge the termination of the contract, the agreement. So there are longer time limits for some actions in order to give the companies the possibility to avoid that drastic reduction. And also, don't forget, for dismissals which are ongoing, that will take place 20 dismissal notified last year. The coming into effect of the order may not have an impact on the overall duration. In other words, it may not addict the 2 years. That was the previous time. Says you give your notification on 1st January 2017. Initially, you can only challenge the validity of your dismissal until the end of May 2019 with the publication. 31st of May, January, June? No, 1st of June 2017 with the publishing of the order 24th September 2017. From that time onwards, you can challenge until the 23rd of September 2018 only. In other words, it's not 2 years, it's 1 year from the date of publishing. So keep this in mind, please. And no effect, of course, on the statute of limitation that were already running at the time publication. So once these traditional measures apply, the rule is 1 year. So it reduces the risk of having this Damocles sword above the head of the employer. As Pierre Humbert said initially, Pierre-André Humbert, earlier today on the Damocles sword and the possibility rather than having 2 years during which the employees might on the very last day come up with a request for remedy or change, it's down to 12 months, which means that we're going back, or they're going back to the statute of limitation you had applied to the validity of the statute. So the rule has become a general one. Now, financial risk and risk of litigation. Here again, for employees, on the employee side, here again, you've explained the main advantages offered by the orders. I'm not going to go back to the standard letter. That again, it's a good thing for the employees because they have better visibility of all the rights listed or entitlements listed on the list. Now, what about the statutory compensation fees or compensation? Yeah, it's up. I think we have a slide on this. You showed it before, even though you were not supposed to show it. So 8 months as opposed to 12 months seniority. 12 down to 8, and the rate has gone up 1/4 months per year by 10 years, and then after 10 years, 1/4, which was 1/5 initially so far, 1/5, which is supposed to take into account a fact of life. Very often, in the majority of cases, the conventional indemnities are higher than the statutory compensation. But if the seniority is not, the number of years is not as high. If the company doesn't have any collective agreement, then of course the statutory compensation has been brought upwards because sometimes the amounts were all too small, even though these employees had been working for many years in the company. And of course, 8 months. But this is an encouragement. It's current practice in our group. We want to make sure that the ratio between statutory as opposed to conventional compensation is okay. It's according to the seniority or number of years taken on board. The conventional, the agreement-based compensation would be more favorable. You don't even look at the statutory compensation level because it's going to be outdone, as it were, or exceeded by the other ones. So you have really to compare the two amounts.
Now, back to the table that we saw before, as you said, Sandra, I think there's a number of cases, even though this is the rule, that is the cap and floor, it's a general rule, there are odd cases for which the table will not be valid. Absolutely. This table is valid in cases of redundancies without serious and real causes, but not if the redundancies are null and void. It's going to be 6 months in this case. That is, if we go against the fundamental liberties or freedom, it's harassment or discrimination, etc., and also any breaches against a protective type of status, that is occupational accidents, maternity leaves, etc. In this case, the total duration will be 5 years, and this has no impact whatsoever as well on the execution of the work contract. That is, salaries, for instance, and in this case, the duration is 3 years, so 6-month minimum and 5 years for the cases that you've mentioned, that are specific cases. Now that means that employees will have a go at it. They'll try. They will try not to use the table. It was the case before. If you look at actions taken, most of those, well, a lot of those were for moral harassment, also sexual harassment. We were thinking that they were trying to have a go at it, trying something to show that they'd been morally harassed. It's quite tempting. It's even more the case today. That is, the temptation is to say that you were made redundant, but there was harassment at work, and all of the other reasons as well. All of the discrimination reasons, they'll be used. As we said, there's 3-year prescription in terms of salary catch-up, and maybe some employees will say, this 3-year cap is not valid for me because there was discrimination against me compared to other employees. So in this case, we would no longer have 3 years, but 5 years to react, because it would be grounded on discrimination in this case. And all the things that employees can do to go beyond the cap will be arguments that employees will use. And they will use any arguments they can outside of the table. In addition to the redundancies not grounded on serious and real causes, there will be other requests that we will have to foresee beforehand with the companies we work with. Right. And so how much leeway is given to the judges then? What room for maneuver for them if they have to consider their rulings within the table? Now, what about the other employees who want to come up with other arguments? What will the judges' roles be? Well, this is it. This is supposed to be a compulsory table. Will people comply or not? If they do, will judges modulate within the different gradings in the table? We have a cap and floor system, and there's a gap between the floor and cap. So where will the limits be according to the judges? That's going to be interesting. And also, what about the other requests put forward by the employees? It's the case today in terms of harassment, for instance, and discrimination as well, is grounds that are mentioned by the employees, and there's more and more of such disputes that go to the courts. So how will judges react? Where should the cursor be if employees ask for more, something that's not in the table? And of course, the requests will have to be substantiated so that they're accepted by the courts. And what about us? It all depends on the rulings of the judges and the labour courts to start with, or industrial courts. And we are advice as well, legal advice, and that's going to be very important for us. Now, to come back to what we said earlier on, our position was always to say, if you have more requests, what we mean by more requests is, I don't know, moral harassment or prejudice. This is usually what employees come up with, what they request, and usually what we answer to them is that we say, it'll be in the full package. It's for serious reasons. It's going to be connected to a redundancy based on serious grounds. And in any case, you'll get the package, which is usually the case. People get the full financial and benefits package. Now, these will be investigated. These requests will be investigated, and therefore the employees will try and come up with more arguments so that they're heard by the judges and listened to. And in some cases, I think, for instance, when you have a table which is not necessarily the one that the labour courts would have used or industrial courts would have used, they would say, okay, I'll grant them more damages for moral reasons because I can't give them these benefits within this table, so I'll give them more. I'll award them more than they're entitled to. That's the risk. We'll see what the first rulings look like to see what the industrial courts will be doing with the table. For the time being, there was no obligation to use the table, and we were told that the judges wouldn't abide by these rules, or if you will, that is the table. We'll see what they're going to do. Now they have a broad type of table, and as Mr. Albert was saying, it really mirrors a reality. We'll see. Even though there's a trade union outcry, they're saying it's not normal. There are exceptions, though, and I think that the employees will seize this opportunity. So there's a lot to work on in terms of disputes in the years and months to come. Thank you for being with us. Thank you for this very lively discussion that was